Andrea, it's June 10th, 2022. And obviously, Rob Garson here from GS2 Law, together with Andrea Timpone. Andrea, the legal week, it's been a very busy legal week this week with, Judge Kavanaugh, Stalker being found outside his home. There have been, hearings that have been going on within Washington regarding January 6th, etc., etc.
Right.
What from the world of IP has interested you this week?
Yeah, so happy Friday, by the way. So I noticed quite interestingly that there's a lawsuit happening over the Top Gun Maverick movie that just came out with Tom Cruise.
Great movie. Have you seen it?
I actually haven't, and I actually got scolded about this by a friend earlier this week. She couldn't believe that I could possibly say that I appreciate the 1980s without having seen the original Top Gun that came out. And I think it was like 1986 or something. Have you seen it? And if so, could you give me like a quick review of, your ideas about the movie?
Fabulous movie. An audiovisual spectacle. I think it's, just so you know, I've not been sponsored by by Maverick or Top Gun the movie or Paramount. We have no affiliation in any manner whatsoever.
Very important to say, by the way.
I think it is.
Good call.
Here's our disclaimer. But it's fabulous movie, really well put together. Tom Cruise showing that he really is a leading actor that can pin down or can hold down if you're going to call it a movie franchise like this, something that's been long awaited for all of us people that, when we drive, say there's a highway to the danger zone, that sort of thing. But they're pretty relatively formulaic this time that Maverick is being brought back as a Top Gun instructor to take action against some undisclosed country for building a really bad weaponish sort of thing. And it, is all good fun in the air with supersonic planes.
So let me ask you a question, because I haven't seen the one from the 80s and I haven't seen the one that just came out. When the one in the 80s wrapped, was there any indication that there was going to be a sequel? Because this latest one is a sequel to the first one, right?
Yes and no. It's a loose sequel. It's got some of the same characters involved, but I don't think you can really call it the sequel when you've got 30 years apart.
Okay. Yeah, because my understanding of it is the 86 movie was based on an article, right? And the author of that article is now suing Paramount for copyright infringement over this movie. They're claiming that the movie is substantially similar. This 2022 movie is substantially similar to the original article that was written. And so I'm just trying to parse out how they're finding substantial similarity. I mean, you're mentioning that it doesn't seem like there was a sequel, 30 years ago. There's different characters involved this time. As someone that's seen, have you seen the 22 one?
Yep.
Okay, so by just viewing that one, do you feel like there's a substantial similarity? Or do you feel like Paramount sort of taken this movie outside the realm of that author's original article?
Well, let's try and break it down into sequences. So Toberoff, the lawyer who's brought this case, is an expert, so to speak, in recapturing copyrights. There are different types of the way that movie companies can acquire copyright. Sometimes it's by virtue of a work for hire agreement. Sometimes it's like this one, where there was an older article, they purchased the rights to that article. And even so, the original movie didn't bear that much substantial similarity to that original article. Now, with certain types of copyrights, especially those that were sold after a certain date, after a certain time, you can recapture those copyrights. This is something that was brought into the law to stop artists who are sometimes poorer people who are, living in their garret in the old Toulouse-Lautrec sort of way, living in their garret and painting away, selling something. They can recapture their copyright later on. And this is what Toberoff specializes in. He specializes in recapturing those copyrights and then saying to somebody like Paramount, oh, hold on, you can't do anything further with this because we never licensed it to you. So there are multiple stages and questions that are going on in this case. First, when they recaptured a copyright, does that necessarily make this secondary movie a derivative work of that first original copyright? That's question number one. Question number two is, and this is going to be an intensely factual question, because I think it was January of 2020 when they recaptured this copyright.
Right.
Was this movie produced, if we're going to call that, within the uncaptured time or within the recaptured time? Because according to the word on the street in Hollywood, the Maverick movie was actually completed in 2019. So it finished filming in 2019, went into its post-production phase, and Tom Cruise refused to let it be released on the small screen during COVID. If that's right, that he held out, that everything was finished basically in that time, then Toberoff is up the creek without the proverbial paddle to start with.
Wow. Okay. So that addresses the allegations of the complaint that the production wasn't finished until 2021. It looks like this is largely something for Discovery.
It may be something for Discovery, or are lawyers using this upon information and belief that we use when we draft liberally or with some form of precision?
Mm-hmm. Yeah, I mean, it's interesting because I don't know if this is really a great look for Paramount. And just taking a quick look at this matter, I also saw that Paramount had a few years ago a dispute as well with Mario Puzo, that Paramount actually had sued Puzo's estate, trying to prevent the estate from releasing another book. They were trying to enforce publication rights over that work. So Paramount seems to be really locking down on whatever licenses and contracts that they're having. I mean, do you think that so I understand that this latest lawsuit was filed in the Central District of California. I mean, is that a jurisdiction that you find could be favorable to the big movie industry players or the smaller authors? Because I know Puzo seemed to be doing okay in the Southern District. I know Judge Nathan found that his estate possibly had a counterclaim. I'm not quite sure where that shook out at the end of it, but do you feel like the Central District of California maybe is a better venue for a dispute like this?
Well, we're both dealing with a case in the Central District of California at the moment, so we've got some experience of dealing with that jurisdiction. It's interesting because California really is the heart of the movie making world. Why was it brought there? There may be a number of reasons, because you would think that Paramount may, because everybody in California is either in the movie industry or wants to be in the movie industry, even if you're a doctor, would they receive a fairer shake as against one of the behemoths in the industry in California versus New York? This may be something to do with the rights of the estate and how estates are viewed in California versus New York. Because you've got to remember, this isn't the original author saying, hey, this is something I was entitled to. This is now the estate. So those who are entitled or feel entitled to something that they never produced or they never made themselves. This whole concept of posthumous rights that we see in the Marilyn Monroe estate sort of situation, those deliberity sort of cases are normally given a fairer shake in California, not a fairer shake, or viewed with more of a gentle eye in California than in New York, which is much more business and sarcastic and maybe more their whole lives don't revolve around the celebrity in the same way that they do in California.
Right. That makes sense.
So that has it. So that's has it. Why would it be in California? That's where the heart of it. We see there's injunctive relief that they're also applying for. I don't think that's going anywhere. I don't think the California court is going to stop the release of Maverick. The question is this estate going to be entitled to anything? And the countervailing issues are as follows: is the Yanai or the author was originally credited in the original movie with a based on his article or based on his story credit. He's not the writer of the story of the screenplay, but it's a loosely based on his story, an underlying right or a life right. From what I've seen in the complaint, the original movie wasn't too close to the Yanai story, but it may have been close enough to give him something and a little bit of royalty. This second movie is certainly based on the characters of the first movie, but I'm not sure the character, what they did in the first movie was really that closely allied to the original copyright in the first place. So I think there's going to be like a chain of causation of derivative work that they're also going to have to get over. They're going to have to get over in order to prove liability. To me, this seems like one of those cases where there's a little bit of a shakedown by Toberoff. Paramount will say, oh, stuff it, here's a little bit of money and go away. And they'll go away.
Yeah, because I'm thinking, I mean, at the end of the day, what are the damages, right?
It depends whether or not Paramount, they were negotiating with Paramount at all the time of making a movie, or whether or not, because this January 2020 date may have been after the movie was substantially filmed or already made. So then it's, you know, this is like those people or those lawyers that send people in to go and slip and fall in a place or go and use a certain type of bathroom that's not in accordance with the ADA. Toberoff looks for these sorts of situations whereby a movie is making something and there may be some vestigial estates out there that could claim something back. It's an easy shake. And well, it depends. Had they properly recaptured and properly relicensed, there could have been a couple of million in it for the for the family members. Right. And they may have, you know, it is a little bit of David and Goliath going on here, right, where David is saying, "Oi, you big bag person has taken our monies, or taken what was would have rightfully been my dad's had he been alive." You can imagine the opening speech in this sort of case. Haven't they made enough?
Yes, and no, absolutely. Okay, I got one last question for you, Rob. So turning from the offensive claims and to the more defensive claims that Paramount might be able to make, do you think that there's a potential fair use defense here?
Fair use, I just think it's a breaking of the copyright, that chain of causation of saying this is such a different story. This has nothing to do with that. Please show me where in that story here it bears any similarity to what we're doing here.
Right.
And that it depends how the court in California, whether or not they'll take a strict or expansive reading of what copyright is.
Yeah.
And that's where I think this realistically boils down to. Is it the concept or is it the story? And right, that's something which could realistically be adjudged quite differently between judges and between clerks who normally do the work for the judges. Of course, the judges would never dream of just fobbing everything off onto their clerks, but that's the way it is.
Well, it sounds like I'm going to have to go see this movie. I'm going to have to watch the 86 movie, and then maybe we can talk a little bit more about, you know, whether or not it's a classic tale that was sort of already there outside of this article, that they pulled other material from outside this article, or if there's actually a valid claim here for copyright infringement.
I'll do that, and maybe we'll get a follow-up when we see what goes on. I expect there to be quite a staunch motion to dismiss coming in here from Paramount.